All right. Good evening, everyone. My name is Angie Pham, and I'm the Community Development Worker at Waterloo Region Community Legal Services. Hillary is unable to join us this evening, so on behalf of the MSW Field Office at Laurier's Faculty of Social Work, I'd like to welcome you to this evening's legal information workshop on housing law. I'll be monitoring the chat box if anyone has any questions along the way. And as a disclaimer, this session is being recorded and will be posted to our YouTube channel for those who could not attend. If you have any questions regarding your registration, please contact Hillary at mswfield@wlu.ca. And before we begin the presentation, I'd like to offer a land acknowledgement. The Faculty of Social Work is situated on Laurier's Kitchener campus, and that's where I too am located this evening in Kitchener, Ontario. Both Laurier and Waterloo Region Community Legal Services are located on the traditional territories of the Anishinaabe, Haudenosaunee, and Neutral peoples. I wish everyone an informative session this evening, and as a fellow MSW student myself, I think that this information will be very helpful for us in our practice with vulnerable individuals. On that note, please allow me to also introduce this evening's presenter, Kristen Thompson. Kristen has been working at our community legal clinic for over 4 years and has joined before joining law school, she attended Wilfrid Laurier University as well. Kristen now specializes in housing law, income maintenance, which includes Ontario Works, ODSP, CPPD, etc., and consumer protection. She's embracing the winter months in Waterloo Region on the outdoor rinks and tobogganing hills with her young kids. So thank you again for joining us, and thank you, Kristen. I'll turn it over to you.
Well, thanks for having me. So my presentation today will probably be about 25 minutes in length, and then we'll have some time for questions at the end. But if you have any questions that you want to ask or clarification beforehand, please let Angie know. So today we are talking about housing law. Housing law in Ontario is under the Residential Tenancies Act. So we'll talk about who's protected under the Residential Tenancies Act. We'll get into some more detail about evictions, so common reasons for evictions, the Landlord and Tenant Board eviction process, and COVID and evictions. We'll also talk about some recent Residential Tenancy Act changes, including the standard form lease, 2022 rent increases, and the landlord's ability to pursue a previous tenant now. Like I said before, you are welcome to ask questions at any time. Please put it in the chat box. And at the end of the presentation, we will stop recording and you can ask other questions that you didn't feel comfortable with asking on record. Now, of course, for the disclaimer. So the following information is considered legal information and is not to be construed as legal advice. Every case is different depending on the facts, and you should consult with a lawyer or paralegal about your issue, or give us a call at Waterloo Region Community Legal Services. All right, now about the Residential Tenancies Act. So like I said before, the Residential Tenancies Act is a piece of Ontario legislation that guides the relationship between landlords and tenants. So most tenants are protected under the RTA. So this includes if you rent an apartment, if you rent a condo from the owner, or an all seasons mobile home. It includes rooming houses. So if you rent a room in a house but are sharing bathroom, kitchen with other renters, you are protected under the Residential Tenancies Act. It includes retirement homes, which are also known as care homes. It includes the long-term rehab or therapy services, and it includes rent geared to income units and nonprofits. So for example, the region of Waterloo has a number of buildings that they own that are rent geared to income that persons can apply for a rent that is obviously geared to their income. Those are protected under the Residential Tenancies Act. We'll talk a bit more afterwards about what that means. Some tenants, however, are not protected under the Act. Most commonly, that includes if a tenant shares a bathroom or a kitchen with the owner. So if you have moved into someone's house, you're sharing the bathroom or kitchen with him, or certain close relatives of the owner, then you are not protected under the Residential Tenancies Act. Those in hospitals and long-term care and emergency shelters are not protected under the Act. Those with short-term rehab or therapy services, and those accommodations provided by an educational institution to its students in some cases. So that is basically if you're living at the Laurier residence. So what does Residential Tenancy Act protection means? It means that you have a right to an eviction hearing in front of the Landlord and Tenant Board, and you cannot be evicted without that hearing. So what the Landlord and Tenant Board is, it's a quasi-judicial court, basically, and it decides disputes between landlords and tenants. They are the board that will actually order the eviction. So if you're not protected, so if you fall under any of these categories, so you're sharing a bathroom or a kitchen with the owner, you live in student residence, you don't have the right to a landlord and tenant board hearing, it means that you can be evicted at any point in time. Residential Tenancies Act protection also includes the right to enforce tenant issues in most cases in front of the landlord and tenant board. So for example, if your landlord is not maintaining your unit properly, if you've been illegally evicted or illegal entry to your unit, if you're being harassed by another tenant or the landlord, or if the landlord has charged you an illegal rent, then you can bring an application to the landlord and tenant board for the board to make a decision on your set of facts. So a bit more about tenant issues. What we often see are maintenance concerns. And there is a bit of a process that you have to go through first before you can bring a complaint to the landlord and tenant board. Namely, you need to tell your landlord in writing about the maintenance issue and essentially give the landlord an opportunity to address that maintenance issue. We recommend keeping a copy of any correspondence between you and the landlord, along with any other evidence, pictures, for example. You don't have to, but it is a very good idea to make a complaint to property standards. So at the local municipal government. So you're contacting bylaw, AKA property standards for the city of Waterloo or for the city of, of Kitchener. They have people that do inspections for the unit. Sorry, just one second. I have young kids and it's apparently time for everyone to start playing Roblox. So property standards will come into the unit and make sure it complies with all codes. So for example, electrical issues, they might do a report for your landlord to comply with electrical standards or plumbing standards. So for other tenant concerns, it's important to keep notes, the date, time, what happened, who was involved. That can be for harassment, for example, and to provide any evidence, so pictures, police reports, that type of thing. It's also a good idea to advise your landlord of any other tenant issues that you're having. After that, you can seek legal advice and you can make an application with the landlord and tenant board for certain remedies. So that could include ending your lease. It could include an abatement in rent, which is a decrease in rent. It could include an order for the landlord to do something. So to provide you with a new fridge if your fridge is broken, for example. So as for evictions, there's only certain reasons that a tenant can be evicted. So for example, a tenant cannot be evicted when the lease comes to an end. Instead, the lease goes on a month-to-month basis. But there are certain reasons that you can be evicted, and these are the main ones. So a non-payment of rent, you've fallen into rent arrears, interference with others, so noise, the behavior of you or your guests are interfering with other rental housing tenants, tenant-on-tenant issues or damage. You could be evicted for a legal act or a serious problem, and the landlord or purchaser moving into the unit, or renovations requiring vacant possession of the rental unit. So I want to show you what a typical notice of eviction looks like. So this is the first step in the eviction process. So this is the N5, the notice to end your tenancy for interfering with others, damage, or overcrowding. It will list the tenant's name, the landlord's name, and the rental unit. It's quite a scary notice to get because of the box that says this is a legal notice that could lead to you being evicted from your home. I'm giving you this notice because I want to end your tenancy. I want you to move out of your rental unit by the following termination date. So there are many tenants that believe that they do have to move out by that termination date. But in actual fact, you have the right to a landlord and tenant board hearing. The landlord has to pursue that eviction in front of the landlord and tenant board, and it's the landlord and tenant board that will decide whether you are evicted or not. So we'll go about the hearing process soon, but I just wanted to give a bit more information on two common eviction applications that we get a lot of questions on. So the N12, that's eviction because the owner or a purchaser wants to move into the unit. And the N13, so rent evictions, eviction in order for the landlord to renovate the unit. In terms of the N12, the landlord is required to give you compensation of 1 month's rent. If it's for the purchaser to move in, then there must be a signed purchase and sale agreement. And the landlord's required to give you at least 60 days notice to the end of the term. In regards to the N13 for renovations, it does require renovations so extensive that vacant possession is allowed. So not just fixing a fridge, but something that requires you to actually move out so that it can be fixed. So the plumbing is going off for a while, the electricity is going off for an unknown period of time, and it does require that the landlord is required to get a building permit from the city. So this notice gives you 120 days notice to the end of the term, and a tenant does have the right to move back into the unit. The right to move back in is at the same amount of rent and all the other same terms as your original lease agreement. There is some compensation that the landlord is required to give you depending on how many units are in the rental complex. So compensation can be anywhere between 1 to 3 months rent. Now, in terms of the eviction process, there's basically a 3-step process. So first, the landlord has to give you that notice that we talked about. And some notices can be voided. So some can go away if you take certain action. So you can void an eviction notice for rent arrears by paying off the arrears. You can void the first N5 for behavior by stopping the behavior or by paying for the damage, depending on what's in the notice. If you haven't voided the notice, then the landlord applies to the Landlord and Tenant Board for an eviction hearing. Right now, eviction hearings are heard on Zoom, and they take between 1 to 3 months to get a hearing. There's basically a few things that can happen at the hearing. So first, there's the ability to mediate an agreement or an order with terms. So what that means is in terms of arrears, you might agree to pay your monthly rent on time on the 1st, and then mid-month you pay an amount towards the arrears for a 6-month period. Or there might be an order with terms that say there's to be no excessive noise in the rental unit. The worst case scenario is the standard 11-day order. So that is the Landlord and Tenant Board giving you 11 days in order to vacate the unit. And there's the ability for the Landlord and Tenant Board to delay the eviction order. So say, for example, that N12, the purchaser moving in is found to be in good faith, but the tenant's having a hard time finding the unit. The Landlord and Tenant Board might give them a month to 3 months longer to find a new rental unit. Once there is a Landlord and Tenant Board order, it's not the landlord that actually carries out that eviction order. Instead, the order is brought to the Court Enforcement Office, also known as the Sheriff Office. The sheriff will give about 10 days before they attend at the rental unit to change locks. So a bit about COVID and evictions. There is currently no moratorium on evictions, so tenants are being evicted. There were some previous moratoriums during the larger waves. There is, however, some consideration for COVID that's new under the Residential Tenancies Act. And that is that there was a new law requiring the Landlord and Tenant Board to consider whether the landlord has attempted to negotiate a repayment plan looking at those COVID considerations. You know, I lost my job for a period of time, but now I'm back to work. I can afford the rent and a repayment plan. I have also noticed the repayment plans for arrears are a lot longer. Pre-COVID, I'd say repayment plans were 2 to 3 months. Now I'm seeing repayment plans 6 to 12 months or even longer. Under the Residential Tenancies Act, you are required to sign a standard form lease when you enter into a tenancy agreement. And this started on April 30th, 2018. So as of right now, both landlord and tenant are required to sign that lease. It's quite a large lease. It goes through all the conditions of the lease along with other tenant rights information. So the lease will list the parties, the contact information, the address of the rental unit. It will list the monthly rent and the term length of the tenancy. Is it a month-to-month lease? Is it a 1-year lease? Is it longer than a 1-year lease? It'll also include who is responsible for the utilities. If there is a rent deposit, of course, your rent deposit can only be an amount of last month's rent deposit. So 1 month's rent and can't be any more than that. And it will say whether tenant's insurance is required or not. I do recommend that tenants look into tenant's insurance, whether or not it is required under your lease. So you can get tenant's insurance, for example, if it's an act of God, so it's not a maintenance issue, but you're not able to live there, then the tenant's insurance can provide you with compensation to live elsewhere in the meantime, to cover your belongings. Tenant's insurance can also include liability insurance for the tenants as well. In terms of the rent increase, so the rent increase for most units, not all units, but most units for this year is 1.2%. There was no rent increase in 2021. That's the year that we had the rent freeze, but rents are able to be increased this year. To legally increase a rent, the landlord must provide the notice of rent increase form. The form requires the landlord to give a tenant 90 days notice, and rent can only be increased once every 12 months. Anything beyond that would be an illegal renter charge, and the tenant could bring the landlord to the Landlord and Tenant Board for their own tenant application if that happens. As of September 1st of 2021, there is a new section in the Residential Tenancies Act that allows the landlord to pursue a previous tenant at the Landlord and Tenant Board. So before this date, the landlord could only pursue a previous tenant, as in a tenant that's moved out of the rental unit, not in possession of the rental unit at the small claims court. But now the landlord can pursue tenants under the Landlord and Tenant Board for rent owing, for damages. So for example, upon inspection, when the tenant moves out, the landlord finds some willful and negligent damage done by the tenant, and they can pursue that tenant at the Landlord and Tenant Board. They can pursue for any utilities. So if the landlord was paying for the utilities and the tenant was compensating the landlord and wasn't paying, then the landlord can pursue the tenant for utilities and other expenses. So for that, I would suggest that tenants take certain actions to protect themselves. So for example, making sure that they can prove all the rent payments and doing not only move-in inspection pictures, but move-out inspection pictures, so you can show the state of your unit when you moved out. Landlords are subject to the Human Rights Code. So that means that they do have a duty to accommodate. So for example, if a tenant is disabled, they have the duty to accommodate to the point of undue hardship. So that might mean making changes to the unit's bathroom or their kitchen, the entrance area or parking areas so the tenant can access those areas. The landlord also has a duty to accommodate in other human rights grounds, so race, citizenship, gender identity, for example. So Other ways that a landlord might accommodate a tenant would be how they communicate with a tenant. So for example, I've had a number of tenants with mental health issues that are triggered when they get correspondence from the landlord that's not in writing, or the landlord communicates solely with the support person and not with the tenant, him or herself. So at the end of the day, for example, if it's a disability related accommodation, the tenant may have to provide some relevant medical or personal information, and there is a dialogue that has to happen between the landlord and the tenant to make sure that accommodation means are met. All right, so lastly, I want to let you know of some super helpful resources. First, property standards. So that is, again, contacting your city bylaw department if there's issues in the rental unit regarding heat, plumbing, structure, water issues. The rental housing enforcement unit, so they are colloquially the housing police. They're through the Ministry of Municipal Affairs and Housing, and they often help with illegal evictions and other offenses under the Residential Tenancies Act. So for example, if a tenant is being evicted without the landlord bringing them to the Landlord and Tenant Board, the rental housing enforcement unit can get involved. Oftentimes what they do is they have a conversation with the landlord to advise the landlord of their obligations under the Residential Tenancies Act. The Waterloo Regional Police, especially their community officers, are very helpful in dealing with tenant on tenant or tenant on landlord issues. Community Legal Education Ontario, they are part of the clinic system in which we are involved in, and they have very easy to read legal information. And finally, in our area, Luther Wood Housing Services, they provide the rent bank services. So they do assistance with arrears, and they're also an access point to shelters and other housing needs. So when you're out there in the field, I mean, really the best that you can do is making sure that you can identify an issue. So identify that one of your clients is having a housing issue, and then know where to connect. So one of the places that you can connect is with us at Waterloo Region Community Legal Services. We can provide most low-income persons with summary advice or with representation in front of the Landlord and Tenant Board, along with other legal assistance. So thank you, everyone. End the slideshow. And then here, let me stop share, and we'll have a chance to go through any questions that you might have.
Thank you so much, Kristen. I'm going to stop the recording, so if anybody has any more personal questions to ask, they can do so.